reconvening. The next matter to come before the court is Rodney Bowerman versus William Taylor, MD et al. Each party will have, we have 3 parties. Have you had a discussion? We have cross appeals, cross appellants. Have you determined how you're going to share your time? Discuss that ahead of time? Yes? Yes. Okay, you may approach. Each side will have 15 minutes in which to present the case. As the appellant, you may retain up to 15 minutes, 5 minutes for rebuttal. I'll keep you track of the clock and we'll keep you apprised of the passage of time if you let me know when you come to the podium. We are being visually and audibly recorded to be posted online, so please try to remain behind the podium as much as possible. We have read your briefs and we're ready to proceed with you.
Thank you, Your Honor. Good morning. My name is Steve Crandall. I was the trial lawyer for the Bowermans. It is ironic that we are here literally a year to the week that the verdict against the Bowermans was announced. This is obviously called an appeal, and I'm appealing to the 3 of you to reverse what I believe to be one of the biggest miscarriages of justice that I've been part of. Prior to being a lawyer for the patient or the plaintiff, I was a defense lawyer for over 10 years. I tried dozens and dozens of cases on the defense side. Statistically speaking, when I walked in a courtroom as a defense lawyer, I had a 90% likelihood of winning. I joke with my defense friends that it's probably the easiest job I ever had. As a defense lawyer, if you have the advantages that the defense had in this case, which is to present a defense, an affirmative defense, of contributory negligence without the requirement for any expert testimony, without the requirement of any burden of proof, it makes it 100% lock that you're going to win that case. Despite the fact that you have no proximate cause defense whatsoever, despite the fact that the case literally came down to what was on the film and whether it was the standard of care to mention it in the report, and what was on the film was about the size of a small football. So what the defense did in this case, and the court allowed him to do it, and I would note that it was the trial court's first case ever as a court of common pleas judge. What the court allowed Dr. Taylor's counsel to do is to not only say that Rod's diabetes was uncontrolled, which was mentioned in a record 2 years before the negligent act took place, but blame him for that mention in the records of an uncontrolled diabetes. And what went on throughout the case was a simple one. Don't look at the film, because if you do, you're going to find my doctor negligent. Look elsewhere. And where elsewhere was, is that Rod was a diabetic. Rod didn't eat right. Rod didn't take his medications. Rod's to blame for this infection. And Rod's to blame for the infection spreading and allegedly not being able to be treated. Not only were they allowed to do this without the burden of proof or any expert testimony, but I asked the judge for a continuing objection so as not to interfere, because I knew that decision was there. I was denied that right. I asked for instructions to the jury to explain what it is that we were dealing with. They withdrew their contributory negligence affirmative defense, but yet they were still bringing one forward, so I didn't know what this was. And I asked for an instruction so that there could be some sense made to the jury as to what they were hearing and why this was important. I was denied that. I asked for an interrogatory so that I could affirmatively say to you today, when you said, well, what impact does that have on the trial, Steve? I asked for an interrogatory to spell that out, because I knew I'd be standing in front of you today, most likely. And I was denied that right to have an interrogatory so the jury could explain how much this attack on Rod and his disease process figured into the decision making. And so it was a miscarriage of justice. And I knew before the trial started, and I put this in my brief, I said this to the judge, these are the types of things that swing cases. when it's a closed case, because the juries always try to side with the doctors, when it's a closed case and the jury has an out, and that out is that Rod didn't do something right, Rod didn't take care of himself, Rod let his diabetes get out of control, then the jury's going to take that out. And that's exactly what they did in a 6-2 decision. In relation to a retrial in this case, if this case were retrialed and retried properly, it could literally be done in 5 days. Because there was no proximate cause defense. Either make the defense sustain their burden on contributory negligence or not, and try the case on what it was really about. Which is, do you simply put in an interpretation that you see a large white lucency on the film? And it could be important, or it could not be important, but to the clinicians, take a look at this. That was what the whole case was about. We weren't asking the radiologist to do a whole lot. In regard to Summa and the Clark claim, I will only say that this was exactly what Clark v. Southview has enunciated. Rod was in the Summa system. He had enjoyed the Summa system. He went to the emergency department that day to seek care from the Summa system. He was admitted, and the film was read by a physician that he had never met before. That meets all the criteria for Clark versus Southview. There is an enunciation by the Summa Council that there is some sort of specialized second prong that Rod needed to prove that he looked to the hospital system and that the notice wasn't sufficient. There is ample case law to describe just this situation. That when you come into the ER in immense pain and someone stuffs a consent form in front of you that has on there, amongst many other things, that the doctors are possibly independent contractors and you sign it, that's not effective notice. So in regard to this case, hopefully we retry this case. When you make the right decision, I believe the case should be tried against Dr. Taylor in the method that it should be, the way the rules required. And I believe that Summa should be there to defend Dr. Taylor under agency estoppel theories as enunciated clearly in Clark v. Southview.
Counsel, are you asserting that the mention of your client's diabetes should have been prohibited?
No.
Period? Okay.
No, I
didn't think so.
I see a big distinction, Your Honor. Saying that Rod had diabetes means he has an increased risk of infection over the general population. That is quite different than saying Rod's diabetes was uncontrolled 3 years before this incident, and it was his fault that it was uncontrolled. And then to extrapolate that and say that that uncontrolled diabetes is why he got the infection and why it wouldn't have mattered anyway with treatment. That's altogether different. And your question reminds me of another thing that was particularly aggravating, that Rod had an infection in his lung in 2012, and counsel brought it up and talked about it with experts as if they were at a coffee shop. Remember that 2012 infection? Yeah, I do. Wasn't that interesting? Yeah, it was. He had an infection before then. It took a long time to heal. Yeah, it did. Okay. The expert never said it was related. The expert never said that it impacted the film that Dr. Taylor misread. The expert never said it meant that he couldn't heal from that infection in 2015. But the judge allowed counsel to talk about it and plant the seed in the jury's mind that Rod was this kind of guy who, through his own fault, didn't heal well and got all these infections. And it really doesn't matter anyway, so just look the other way when it comes to that film. That was what was unfair to Rod and Hillary. And that's what should have been prevented, or there should have been requirements of expert testimony, there should have been requirements of meeting the burden of proof, there should have been requirements for jury instructions and jury interrogatories, just like apply to me when I try to prove something in a court of law. I think I forgot to say that I was going to ask for 5 minutes.
We have about 6.5 right now.
Okay. Unless there's any other questions, I reserve I guess the 5 minutes for rebuttal.
Thank you.
Thank you very much. I appreciate it.
Good
morning. My name is Stacy Starchart, and I represented Dr. Taylor during the entire pendency of this lawsuit, including today. As this panel has heard, the entire basis of plaintiff's attempt to appeal a verdict in favor of Dr. Taylor was revolved around the issue of Mr. Bowerman's diabetes. Plaintiff has acknowledged throughout the course of the pretrial discovery, throughout the course of the trial, and even here today, that Mr. Bowerman's diabetes was a relevant medical fact in this case. In fact, it was one of the linchpins in their standard of care prosecution against Dr. Taylor. Because Dr. Taylor knew that Mr. Bowerman was a diabetic, that should have heightened his awareness to attach significance to a finding on this particular imaging study. However, the plaintiff did not want to take all of the facts regarding his diabetic condition into account and let the jury decide the importance of all of the medical facts with respect to his diabetes. The fact that it was uncontrolled, the fact that the reason it was uncontrolled for a period of time was, as his physician indicated, Mr. Bowerman's non-compliance with his diet and his medications. That was all part of the medical record that plaintiff presented to the jury without request for redaction of those medical records, including the lung infection. It was all part of the medical record that the jury had, and that all of the experts reviewed in coming to their conclusions. There was no attempt to redact that from the medical record. But getting to the bottom line, as I tend to try to do, Mr. Bowerman's control, compliance, his diabetes was not the basis of the decision of the jury. All of this has nothing to do with how the jury found. The jury found that Dr. Taylor met the standard of care, or the converse, that the plaintiff did not prove, as they were required to do, that Dr. Taylor deviated from the standard of care. Mr. Bowerman's compliance, control of his diabetes had nothing to do with that issue. That was simply part of his medical condition, that despite plaintiff's counsel's rhetoric, if I may use that term, about unfairness and substantial injustice, there is no proof before this panel today that diabetes, that control, compliance had any impact on that determination. It's all speculation and conjecture on plaintiff's part because they're not satisfied with the jury's verdict. In order to be entitled to a new trial, or JNOV, as the plaintiff is arguing, they have to show some impact. They have to show some impact of this admission of evidence on the jury's verdict. They have to prove that there is no substantial evidence to support the jury's verdict. We had 9 days of trial. We had 19 witnesses, 14 of whom were expert witnesses. There were experts on the plaintiff's side. There were experts on the defense side. There was ample evidence to support the jury's finding that Dr. Taylor met the standard of care, or, again, that the plaintiff failed to prove that. He deviated from the standard of care. There is absolutely no basis in this record for granting a JNOV or a new trial. The court did not abuse its discretion in allowing evidence of Mr. Bowerman's control or non-compliance with his diabetic management before this jury. This was not an abuse of discretion in light of the fact that it was in the medical records, that they didn't ask to be redacted. But the bottom line is it had nothing to do with the primary issue before the jury, the issue that the jury made its decision on. There was never a pursuit of a contributory negligence claim against Mr. Bowerman. If the court reads the almost 1,800 pages of this record over this 9-day trial, there was never one mention of blame to Mr. Bowerman, that he was at fault for his condition, that he was responsible for his injuries. And in fact, in my closing argument, I made that perfectly clear with the jury. We were never blaming Mr. Bowerman. That's why we didn't pursue the contributory negligence claim. It would have been inappropriate to pursue a contributory negligence claim based on the case law cited by plaintiffs in their appellate brief. We never presented expert testimony on it. Never even mentioned negligence of Mr. Bowerman. It was his medical history that the plaintiffs themselves made relevant to the standard of care. presented the jury with the entire picture. So the motion for JNOV, the motion for new trial, the jury instructions, the jury interrogatories, all about contributory negligence were not given because they shouldn't have been given. It would have been reversible error to give an instruction on contributory negligence. It would have been reversible error if there were impact to give that interrogatory that was requested. If there was so much concern about the taint, the highly prejudicial nature of presenting this complete picture to the jury, if there was concern of confusion, an instruction could have been requested clarifying that, but that was not even requested. The instruction that was requested, the interrogatories that were requested, were strict contributory negligence instructions and interrogatories. Could have fashioned an instruction to the jury that said, you have heard evidence of Mr. Bowerman's compliance or non-compliance, of the lack of control of his diabetes, but you are not to consider that when determining issue A or B or C. They didn't even request that.
What compelled you to argue to the jury at the end of the trial that the defense was not making an argument for contributory negligence?
Because the closing argument that I sat through from the plaintiff's counsel was and I don't think I'm stretching it, a personal attack on me for blaming Mr. Bowerman for his condition. I felt the need to clarify to the jury that was not at all what we were doing. Almost the entire trial, there was an assumption and an attack that the defense was blaming Mr. Bowerman. I wanted the jury to be perfectly clear that's not what we were saying.
So it wasn't, and it's not at all, I guess that, like, the question was, the court denied the continuing objection, which would have required Mr. Bowerman's counsel to continue to object.
Which he did not. He did not object. Instead, he chose, which was his strategic decision to do, to get in front of the issue, I guess, with the questions of Mr. Bowerman. He didn't need to do that. He didn't object during my opening statement when I mentioned uncontrolled and noncompliance. Didn't object to that at all. If we are going to fault Judge Lanzinger for failing to give a continuing objection, I think the better course, in light of her decision not to do that, would have been just to object. Give a standard objection every time the issue was mentioned.
Yeah, I just need to understand why it was relevant when we got to the end of the day, and you have answered the question.
Thank you, thank you.
You just said uncontrolled and non-compliant. There's
Yes.
a difference between the two.
There is.
Isn't the latter actually blaming the patient?
I can understand where you would think that. My approach to the issue of noncompliance versus uncontrolled was to state what Dr. Domdera had written in his record. It was a very factual statement about what he had written. And taking that and getting back to the main point that I'm trying to make about prejudice by the introduction of this information to the jury, our court reporter obviously gave us an index for the entire trial. The words non-compliant were mentioned, I've got my chart here, a total of 6 times during 9 days of testimony. 3 of which were mentioned by the plaintiff. The other 3 were mentioned by the defense. 2 of those were in my opening statement. So I don't understand how using that word 6 times over 1,800 pages of testimony could be proven to impact this jury's verdict, especially in light of the verdict being on the standard of care for Dr. Taylor. And the plaintiff is patently wrong in their brief when they say that the jury is to consider the negligence of Dr. Taylor and Mr. Bowerman at the same time if we're dealing with the contributory negligence claim. That's patently false. Even if you look at the OJI, the interrogatories for a case like this, if there is a contributory negligence claim, was the doctor negligent? Did the doctor's negligence approximately cause injury? Then you address whether the patient or the plaintiff, whoever it may be, whether that person was negligent if that person's negligence caused injury, and then you would offset, it diminishes, the plaintiff's negligence diminishes the defendant's negligence and proximate cause of damages. So you don't even get to whether Mr. Bowerman did or didn't do anything wrong, even if that argument were to be made, until you find that the defendant was negligent and they caused injury. The jury didn't even get to the second question.
But could it be though that since this is a failure to put something on a report, negligence claim, standard of care claim, versus I didn't see that claim? In other words, could it be that the causation is so entwined with the standard of care that the jury is not able to separate that when they're making the standard of care determination? I understand that's a pretty obtuse question because we don't know what they were talking about in that jury room, but
Absolutely.
I think but my understanding of plaintiff's argument is it was below the standard of care not to mention it on the report.
Correct. That's exactly the case against Dr. Taylor. And there were several experts, if I recall correctly, from the plaintiff's side that says it was a deviation from the standard of care to not mention something. One of the experts said you should have said it was a finding that meant either infection or something else specifically. However, on the opposite side were experts for the defense that said it was within the standard of care to not include that in the report. So I appreciate your question, but I don't know that I can answer it.
Sure, that's why it still remains a question.
Yeah.
I appreciate that.
I tried to answer it, but I probably
You did.
did not do so well. I think Judge Callahan knows because I've tried cases in front of her that I'm a fairly bottom line person, and the bottom line of this case is all the discussion about diabetes and whether it was controlled or not controlled is irrelevant. The jury found Dr. Taylor met the standard of care. Didn't even address Mr. Bowerman's actions beforehand or concurrent with the alleged negligence. So in order to warrant a new trial, the plaintiff appellant had to show you that the introduction of a handful of references to the word non-compliant, which was part of the record that the jury received, was the sole reason that the jury found for Dr. Taylor as opposed to the plaintiff. They can't do that. If there are no more questions, I will give the rest of the time to Suma's counsel. Thank you.
I will be very brief. Susan Audi for Suma Healthcare. I will be addressing the issues on condition of cross appeal. In the event that this court sustains the Bowerman's assignments of error, we ask that this court reverse the judgment of the trial court denying Suma's motion for directed verdict because the Bowermans failed to present any evidence that Mr. Bowerman looked to Akron City Hospital for his care as is required under Clark. Two cases cited in our brief, at the opening brief at page 12, support our argument. In Cox versus Ohio State University Hospital, a referral was made by the referring physician to the Ohio State University Hospital for care. The referring physician did not treat that physician, did not treat that patient there, did not see that patient, did not manage his care. However, the court said that this was not determinative of whether this was proof of the patient looking to the hospital for his care. So merely because the referring physician made a referral to a hospital, did not manage his care there, that was not sufficient to show that the patient looked to Ohio State University Hospital for his care. The same thing happened in Deer versus River Valley. A referring physician made a referral, this is also on our opening brief, page 12, made a referral to a hospital. That referring physician did not treat that patient there, and the court in that case said as well that this was insufficient evidence to show that the patient looked to. So when you have a referring physician who makes a referral, and that is the reason that the patient goes to that hospital, that is not evidence that the patient looked to the hospital for their care. Now, Bowerman's tried to distinguish the Cox case, saying that the plaintiff in that case, or the patient in that case, or the referring physician in that case, made a referral to a specific doctor. That's immaterial, because if that were the case, then physician part of the Clark claim, so that doesn't make any difference that he made a referral to a specific physician. They also rely on Rio versus Akron General Hospital, saying this is a modern case of how an agency by estoppel claim should be tried or should be pursued. And this doesn't help their argument as well, because in that case, there was evidence that the patient looked to Akron General for their care. He said he went there because it was close to his daughter's home, and he needed emergency room treatment. There was no referral involved. There was nothing that the patient did at the direction of a referring physician. The same thing with Scasari's case. In that case, there was an unconscious patient, and the patient in that case wasn't able to make that or give that type of testimony. What the court did in that case was broaden who could give the look-to testimony and look to the person with the decision-making authority. So none of the cases or none of the distinguishing arguments that plaintiff is making here satisfy his look-to evidence. And we ask this court to, if there is a reversal or sustaining of their assignments of error, that you reverse the judgment denying Suma's motion for directive verdict. Thank you.
Thank you. Well, counsel,
I'm sorry,
quick
did you have a question? I'm sorry.
Hopefully it's a quick question. The facts of this case, okay. Mr. Bowerman did not go through ER, is that correct?
He did go through ER. He did go through ER there.
For the
Yes.
for the radiology test we're talking
Well,
about?
Dr. Dowdera, his primary, said go to Akron City. He followed his directions and went to Akron City. He went through the ER.
Thank you.
Any other questions? I'm sorry, I didn't mean to leave you. Thank you.
Thank you, Anna. In rebuttal, I want to address a couple of points that was made by counsel for Dr. Taylor. She said there was never a pursuit of a contributory negligence claim, and that is completely false. Throughout all of discovery, there was an attempt to obtain expert testimony through my experts and other experts in regard to the contributory negligence claim, and they did plead it in their answer. And I obviously saw this coming, and that's why I filed the motion in limine. And what occurred in the court when we were arguing it was somewhat stunning, and that was, we went to argue the motions, and there was an acknowledgement that she was abandoning that claim. And so there was some discussion of, oh, okay, then it's just moot. And then she said, no, I'm still going to use the evidence. So to say that there was not a contributory negligence claim pursued, there was the entire time. They struck out at it, but they admitted, we're going to use the evidence anyway. In regard to whether it was just uncontrolled or there was blame, I was searching through my computer, but then counsel for Dr. Taylor admitted she used the word non-compliant in association with that 3 times. There was an allegation that it was not only not controlled, but it was because of Mr. Bowerman that it was not controlled. Whether it's mentioned 1 time, 3 times, or 10 times, the impact remains the same. And that is that you caused this infection. You're the one who is responsible for it being on the film in the first place. And that makes it easier for someone to look past a radiologist not finding it. And that's what I believe happened in this case. In regard to...
Counsel?
Yes.
Sorry, I have to ask you this.
No problem.
How is this just not, and I don't mean to lessen any impact when I say just, but the fact that the jury or a number of jurors found defendants' witnesses on the issue of standard of care more credible than plaintiffs' witnesses. I mean, clearly they did. How are we supposed to gauge how this uncontrolled diabetes issue had any impact on that? How can we do that?
Well, that's the essence of my appeal.
I know.
Because
But
number,
how?
I tried. I asked for an interrogatory on it
Okay.
so that we knew, which was another one of the points I wanted to make back. I knew this was in play. We aren't in the jury deliberation room. We can't ask them. And if I asked them afterwards, I couldn't say what they said anyway. But I can tell you that if they're trying to figure out if Dr. Taylor's negligent, at the same time they're trying to figure out if Rod was negligent, but yet no expert testimony was required, no burden, then obviously they're weighing the 2 negligence. That's what the claim is about. They were allowed to do that unfettered. They were allowed to do that without any controls to the defense. And so I believe that's how they got a 6-2 verdict. I think it recognizes it was a close call, we didn't really know what to do, and the out is Rod probably should have eaten better and taken his medication, or else he wouldn't have been there in the first place. I believe that to be true, but I asked for an interrogatory that properly should have been given, so that we'd know exactly what that was. In relation to, you know, what I asked, I did ask in my motion to eliminate that all of this be stricken. I asked that people not comment on it. I asked that it not be referred to. Keep in mind, the uncontrolled description occurred by a Dr. Dondera in 2012, 2013. They never called Dr. Dondera. They never deposed Dr. Dondera. And in the intervening between 2013 and 2015, Rod was compliant and Rod did have total control of his diabetes. So imagine if defendants are allowed to go into anyone's medical record and find out that you had something that people don't like. You smoked 3 years before the negligence. You had an STD. Or there was some issue in your medical past that had no relevance, really. They could just bring it up. Yeah, this was in your records. 3 years before the negligence. You didn't take care of your diabetes. You did for the next 3 years, but I'm going to bring it up anyway, and I'm going to say that it had something to do with that infection. Without a single expert connecting those dots. And that's wrong. And that's not how we try medical negligence cases. If I do have any time, I just want to say, I just want to reiterate, we don't know that diabetes was or was not the basis of the jury's decision because I wasn't allowed to give an interrogatory. And that's the reason why I asked it to be done. So I asked that this miscarriage of justice be overturned. I asked that we be allowed to try this case again. And I'm just asking for a fair field when we do. Thank you very much.
Thank you both for your presentations today. The court will take the matter under advisement, issue a written decision, which will be mailed to both sides as well as posted to our website and that of the Supreme Court.